Group E, avoiding unnecessary use of court and custody evaluations. Avoiding unnecessary use of court and custody evaluations. Obviously, we should be, just as the medical profession ought to be steering people toward good exercise and stress reduction and diet and so forth, rather than saying, go ahead and, eat whatever you want, smoke as much as you want, and just come see us once a year for your annual physical and we'll give you more drugs and surgeries and, that'll be good health care. This should be returning responsibility to parents and avoiding the unnecessary use of court and custody evaluations. There are three incidents of what we think need to be done to accomplish this. The first measure is to have in your court rules the requirement that absent an emergency or danger or other special circumstance making it unreasonable, parties must speak, either themselves if they're not represented or by their counsel. They must speak about any matter before it is brought to court, before anything is filed, before we ever bring disarray into this family by saying all of a sudden here's a 5-page motion by one parent calling the other parent, an irresponsible influence in the children's lives. I don't think sometimes we're adequately attentive to how much damage this is doing to families and to the relationships between moms and dads, just that things like that are filed. So there must be a consultation between the attorneys, or if they're not represented, between the parents, or if one parent's represented, the other not, then that attorney, and then the unrepresented attorney or the self-represented parent rather. But there must be a discussion to resolve the matter. Furthermore, if that matter is not resolved in the consultation, then they must discuss 4 additional things. One is, what resources do we individually, or perhaps we agree, what resources do we think these parents could be sent to so that they can resolve future issues? This is a very important point, Very often, even when parents or when attorneys are talking beforehand, they're not talking about the right thing, which is, what does this family really need? And a good way to put that is, how do we resolve, or what do we resolve would be a good place to refer these parents for help so that they can resolve the next issue. The next thing that should be part of that consultation is to briefly check and make sure that the parents are current on all other obligations that have been imposed by the court. Have they completed their website work, and have they completed their co-parenting class? The next thing that ought to be discussed is, have the parents completed a parenting plan worksheet? Can they agree on one? If not, let's confirm counsel at least that your client is going to have his filled out and mine will have hers filled out. And the final thing they should discuss is to confirm that the parents will be bringing to the hearing their parenting plan worksheets and their agreed commitments from their website work. The second component of Group E, about avoiding unnecessary use of court and custody evaluations, is that motions then must include what we call a cooperation update. And I would prefer that it use that exact term, cooperation update, and that would be a paragraph where the moving party, the person filing that pleading, specifically recites when this conversation occurred, this required pre-motion consultation, who was involved in it, and goes through those items. Here were the ideas that were exchanged about where the parents could be sent for help. This is to confirm that the parents are current on their website and classroom experience. This is to confirm that they will be bringing their either combined or their separate parenting plan worksheets, and they will also be bringing their agreed commitments. Shouldn't be anything beyond that. It's not about finger pointing, it's just a cooperation update. And the final requirement is that courts should not give trial dates, and they should not allow custody evaluations until all cooperative measures have been satisfied. So I think these should, and we have some jurisdictions, by the way, in Indiana, that say you do not get a custody evaluation. You're not even allowed to do one on your own unless you certify that all cooperative measures have failed and there's no likelihood that they could succeed. There are a lot of very good articles by Dr. Robert Emery. Doctors Janet Johnston and Joan Kelly have a wonderful article from 2005 about how custody evaluations can be so destructive and how they're so overused, and how they should be limited to cases of domestic violence, psychopathology, or active drug abuse. Very, very extreme cases of not being used, should never be used to try to find the better parent, the somewhat better parent. So those should simply be disallowed until somebody has satisfied the court that they are absolutely necessary.